Hi again. I got continuing with the issue of the property taxes and how they're assessed. For the Value Adjustment Board, I had sent two other letters, one dated September 27th and another one dated October 10th, 2016. For the one on the 27th, they had set a hearing date before the Value Adjustment Board for October 25th. So I write back to the Value Adjustment Board, Dear Value Adjustment Board, please know again that I come to you in peace and in support of the United States. Second, thank you for your implied agreement, acknowledgement, and acceptance that I am a mere exclusive and authorized user of the person, property, or name Anthony Rubeo, since you have corresponded, addressed the matter to the factitious entity instead of me. I use such person, property, or name for the benefit of the principal United States, as I have been left spoliated or naked due to the belligerent occupation of the principal by necessity, the United States. Your intentional agreement to the status was outlined in the cover letter you sent dated September 9, 2016, with an attached authenticated birth record which appears to be usufruct compliant. That was my letter sent to them. Third, it appears that an administrative board hearing has been scheduled for October 25th, 2016. I must thank you for at least not ignoring the issue up to this point in time entirely. I believe the information package you have been provided is complete. Therefore, it would not be necessary for my presence at your public hearing. I could not add or subtract to any of the information at a public hearing, as I believe it to be an internal matter. Without too much doubt, the Value Adjustment Board has attorneys that it can seek counsel to address the issue of 31 USC 3124, U.S. Constitution, statutes, treaties, etc. As I have confessed, I'm not trained in law, nor do I understand legalese. Therefore, how could I be able to provide any consent or understanding within your tribunal setting? I believe it is a simple question that can be answered in writing by the Value Adjustment Board. Otherwise, it will be a dishonor where Lori and the Value Adjustment Board have failed intentionally to address the matter fully and completely. It is a question that I have attempted to have answered in private by Bertha, Lori, Sharon, and Mila, but it appears they have fell silent on such a simple question. The question relates to Lori's authority in her property tax assessment with fair market value of properties in the county of Broward valued in U.S. currency, U.S. dollars in Federal Reserve notes or debt obligations of the United States to assess property and then compute a tax on such fair market valuation. Except if the manner in which Lori assesses property taxes violates your 31 USC 3124, then please simply remove the property from your tax rolls. I can absolutely accept a mistake was made, and it was probably not intentional on Lori's part, or counter. If I am incorrect, then Lori can take fair market value derived from, based upon, solely, or in Federal Reserve notes to compute a tax in her assessment of property taxes. I humbly ask you to forgive my error and to correct me, and forgive us our trespasses as we forgive those who trespass against us, and to please have Lori as property appraiser sign her claim in front of a notary that her property tax assessment, which she issued to Rubio Anthony, a factitious entity or person. I have attached again her claim for assessment notice for her to sign with verbiage that corrects my error. If the attached notice is not returned, signed, and notarized, or condo property removed from Lori's property tax roll, then it is a dishonor. Reject. Thus far, a response for a hearing has been granted. However, a hearing is not needed. It is a matter of she can or she can't with respect to 31 USC 3124. Otherwise, silence equals fraud. where there is a duty to speak. I believe this is suggested in your case law. And then I do the United States versus Twill case. Silence can only be equated with fraud where there is a legal or moral duty to speak, where an inquiry left unanswered would be intentionally misleading. United States of America, plaintiff, blah, 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 all those quotes. And I go on, it is required and demanded that I receive a written response by the Value Adjustment Board as the record is complete and nothing more is required by me for your review and determination. Again, please forgive my writing if it is not perfect. However, I trust the intent is clear. I will not attend any tribunal or administrative hearing as it appears to be an internal matter of private corporate law. All I am looking to do is support the United States and ultimately not suffer any consequences personally with regard to not having shelter because some trustees failed to discharge Lori's property tax assessment claim, where a bill is sent out by County of Broward based upon Lori's property tax assessment. No claim for property tax assessment equals no property tax bill. One final thought I would like to have on the record. I presume the issue of usufruct, cesticate, trust, law of nations, Libra Code, bankruptcy of the United States, etc. is beyond the Value Adjustment Board scope of authority. I tried to discuss this matter to some degree with Bertha, but Sharon chose not to respond. Should Lori sign her notice of assessment, I would like to find an authorized public official who settles claim on behalf of state property. This falls under the rule of usufruct. Any assistance of the Value Adjustment Board would be greatly appreciated. As a note, the clerk who accepted the petition did not accept the check due to the writing on the back. I saw she was nervous with all the persons filing. I did not want to add to this nervousness. I gave the clerk $15 US currency. However, this $15 was redeemed in lawful money at the time a deposit was made, and such deposit and check were endorsed with full discharge is demanded for all transactions per 12 USC 411 and 12 USC 95A. Regardless of a cash check or not, the intent remains the same. I look forward to receiving your determination in writing. I believe my part of this process is now complete, as the Value Adjustment Board and Lori have all the information to review and then respond. Thank you, and may God bless you. Bye. And I put again the notice of tax assessment with the penalties of perjury. What happened, I was reading, I have a big book I use that I put together with various information. I was reading again the Gold Act of 1934. So I decided on the last day due to submit this as well, even though I said on the last letter dated the 27th that was it. And this one again is dated October 10th. Dear Value Adjustment Board, first, please know again I come to you in peace and in support of the United States. I was talking with a friend about the situation. It was suggested that I do attend your hearing on October 25th. Otherwise, the Value Adjustment Board and Lori will simply ignore the matter entirely, and all this effort I put forth will be forfeited. Previously, I had spoken to one of the clerks and said that the information to the Value Adjustment Board is complete, and really there is no reason for me to attend the hearing. She said to let the Value Adjustment Board know, and that it was not necessary for me to be present, and that it was not an issue. I sent an email to the Value Adjustment Board about attending the Value Adjustment hearing, confirming same. I received the following response. As a petitioner, you have the option to have your evidence considered in your absence, or have a telephone hearing if you are unable to attend in person. However, you will need to notify our office of the right you have, like to exercise so that the petition is noticed correctly. And I continue, after I posted this info into your system, I will in fact write an email to the Value Adjustment Board to make aware this info is complete and my presence is not necessary for a determination based upon all the information submitted. Since the information provided is based upon your statutory laws, which I believe by contract or oath of office you are obligated to adhere to and act accordingly, then to enforce, I see no other option or potential controversy other than the removal of the property from your tax rolls. As a final piece of further evidence for the Value Adjustment Board and Lori and all the attorneys to review, I am enclosing the congressional intent to define U.S. currency from the 1934 January 24, 25, and 30 pages 337 through 344, Chapter 6 from the 73rd Congress. From page 344 under Section 15, the Congress appears to have defined the term U.S. currency. And I quote directly from that 1934, excuse me for leaning. I quote directly from the 1934 Act. As used in this Act, the term United States means the government of the United States, and the term the continental United States means the states of the United States, the District of Columbia, and the territory of Alaska. The term currency of the United States means currency which is legal tender in, capitalized, in the United States and includes, or that was what I put, includes United States notes, Treasury notes of 1890, gold certificates, silver certificates, Federal Reserve notes, and circulating notes of the Federal Reserve banks and national banking. I continue on. I am also enclosing select pages from Gold's Reserve Act of 1934, page 133, which the chairman asked the questions. The Federal Reserve System in this country is purely a private banking system. Response from whoever, I would call it semi-public. Chairman asks, owned entirely by private interest? Response, yes. So in essence, what that is Federal Reserve notes are private credit. And the money or the legal tender we have in our pockets or the banks or whatever is private credit that we do not own. It has an irrecusable first lien and it is subject to confiscation at any time because you don't own it. So I continue on with the letter. If these statements are true, and then it would appear that 18 USC 8 and 12 USC 411 apply as Federal Reserve notes are debt obligations of the United States, and under 31 USC 3124, a tax cannot be computed by a state or political subdivision of a state. Further on page 184, once again the definitions are provided for the term U.S. currency. I don't know if I included that. Per Lori's claim or opinion of market value on the condo property of 1105 whatever attached again, based upon the intent of the congressional legislation, does the valuation is $110,570. Based upon the intent of the congressional legislation, does the $110,570 market represent United States notes? The second question, does it represent Treasury notes of 1890? Does the market value represent gold certificates? Does it represent silver certificates? Does it represent circulating notes of the Federal Reserve banks and national banking associations? Or number 6, does the $110,570 market value represent Federal Reserve notes? I am not sure when the last time you went to your local bank, but it does not appear you can be provided or obtain items 1 through 5. However, you can obtain private credit with irrecusable first lien obligations, attachment, and benefit without liability to discharge in or as Federal Reserve notes as U.S. currency, U.S. dollars, or U.S. funds. When the tax bill arrives to the person, it says payment must be made in U.S. funds drawn on U.S. bank account. There is only one option, Federal Reserve notes. Based upon this information provided and submitted to the Value Adjustment Board on September 19th, September 28th, and today, failure to adjudicate the matter according to your law can lead one to the appearance that the Value Adjustment Board and Laurie Parish intend to defraud a person for personal profit and gain. How do you like that? I look forward to receive your determination in writing for the removal of the condo property from your tax rolls. I want to provide some further information for you to review. I wanted to provide some further information for you to review as the issue is important. Just to be clear, the issue is trying to help save the United States before it is too late. Thank you and may God bless you. By Anthony Rubio. Enclosure, an email to confirm the congressional record of 1934, the Gold Reserve Act, and Laurie's tax notice to be signed under penalties of perjury, and a copy of last year's tax bill. So what I received yesterday was very interesting. It was a bunch of gobbledygook, actually 50 pages of it, from the property appraisers as their evidence to this case. Of course, none of it answered what I wrote. It was just attesting to the market value, and of course what they did, beautiful color pictures, and the fair market value, and lawyers' memos to lawyers. Under the statute they can do this, and under the statute they can do that, and they can do this, and they can do that. And then as I just perused all this, it suddenly occurred to me that it's pretty sad, because you have to understand that the property appraiser here in Broward, or I guess in the state of Florida, I guess it applies to all of them. Now I can look at you. They take the market value of the properties located within the county. Then every year they send you out a trim notice. I think it's Truth in the Valuation or something like that, whatever it stands for. And when they send out that notice, they use last year's millage rates. Well, you know, the millage rates come from different entities within the county, such as in Broward we have a hospital district, which is an entity, the water district, which is an entity, the city is an entity, and all these entities set this millage rate. Obviously, Laurie does not. And then what happens when the tax bill comes out, it comes from the county itself, not from the property appraiser. So what it looks like to me, how they may be getting around all this, is one is doing the valuation, one is setting the tax rate, and then one is sending the bill out. So it's three different entities, even though they're all subsidiaries of the United States, or which the state of Florida is a subsidiary, and of course the political subdivisions are subsidiaries of that. So I'm not sure if that's their logic, how they can get away with it, but it's going to be very interesting. As you understand, I'm not attending the hearing that's actually coming up this next week because I don't want to be frustrated. And obviously, you know, it's like when you ask Hillary a question, it's pivot to what is not the question. So I guess they're professional people that cannot tell the truth, and I don't believe by law they're obligated to tell the truth, because if you look under the Libra Code, you know, there's deceptions allowed under war on the land. Again, it's a declared national state of emergency. So at this point, I'll let you know what happens. I'm not too confident they're going to accept this, but I have forwarded this to the governor of the state of Florida and to who is Rick Scott, and to Pam Bondi, who's the Attorney General. Now, again, what is the likelihood there'll be a response?